No patent is granted on the basis of provisional specification. Obviously you understood that, right? So if you do not file a complete application, you will never get a patent granted for it. I hope these points are very much clear to you. Difference between provisional application and complete application. So provisional and complete, they are always associated. There is an option, either you file a provisional or you directly go and file a complete application. Next type of patent application is that it is referred to as patent of addition or continuation. As the name indicates, continuation means what? It's a continuation of the original or earlier filed patent. And similarly, patent of addition means you are doing some addition to the existing patent which is filed. Right? So when we say patent, obviously where you're doing any modification or addition to the invention. So such type of patents are always associated patents. They are generally referred to as associated patents, and they always associated with a parent application or the earlier application to which they overlap. So here the concept of parents come into picture. So parent and child as a biological term, but I'll try to explain in further detail. So whenever you refer to a child, they are always associated with their parents, because without parent, the childs are generally, in a normal scenario, they are not possible. And thus, this patent of addition, when an application is filed as a patent of addition, as the name indicates, they are always associated or connected to their parent, a parent invention or a parent application. Any modification or any improvement that is happening in any invention today can be considered for filing a patent of addition. Any modification or improvement, right? I hope this is clear to you. So any modification or improvement can be to an extent that you modify your invention. For example, today I am saying that my vehicle runs on only water, and tomorrow somebody says that my vehicle runs on, for example, sewage water. Yeah, though it is a water, but specifically it is a sewage water. And earlier the patent that I filed was having only water to it, but I want to now file a patent for sewage water as well. Since none of the functionality or the operation of working changes, it's only the specific input, that is the type of water that is being used, changes, and hence that is considered as a eligible subject matter for patent of addition. So even when you file a patent, it is not that you cannot file another patent which is based on the similar subject matter with some improvement or modification. You can do that, but under the category of patent of addition. Most important points to be considered when you file a patent of addition. When you file a patent of addition, your life of that patent of 20 years get finished as soon as the life of the parent application is finished. That means the total time period that you get for the patent of addition is equivalent to the total life of the parent application, right? However, there is an upside to it as well. Upside is that in the worst case, if your parent application for the patent is cancelled or rejected by the patent office, then automatically this patent of addition can be considered or can be treated as a new separate application, and you can consider it as a separate entity altogether or a new application file altogether. So in such cases, the life of the patent does not depend on the parent of the patent of addition, but it will be completely 20 years from the date of filing of the patent of addition application, right? So patent of addition, I hope it is clear. These three are the simplest form of patent applications that you see in the globe today. So provisional application, complete application, and then what? And then you have patent of addition. Divisional application is another type of application. So now let us take an example, okay? What generally people do is, like, they come up with an invention which has multiple novelties or multiple uniqueness in their invention. For example, my invention is about a water bottle and a refrigerator. So this water bottle is a very unique water bottle which can automatically refill itself. Similar to when you recharge your battery, this bottle also has to be kept on a particular device and it automatically refills. That's the invention. But I also came up with another invention wherein this refrigerator has a device which helps to fill the water bottle inside the refrigerator. So as soon as you put your water bottle in the refrigerator, it checks whether the water bottle is empty or not, and it automatically fills it. So you may have noted that there are two inventions to this. One invention is about a water bottle which automatically refills, and second is about a refrigerator which has a specific mechanism to fill the water bottle inside the refrigerator. Now, these two inventions can operate separately, can be sold separately, can be performed separately, right? Because refrigerator has its own mechanism, whereas this device to refill the water bottle has a separate mechanism to it, and they are not fitted into refrigerator and each other, right? So what happened was, like, I was not aware of that situation, and what I did is, like, to save the money, I filed these two inventions in a single document. So patent office, what they do is, like, during examination, they identify that there are two inventions in this because they can work independently of each other. So either one of the invention has to be cancelled, or there is a possibility that you can file another application at any stage after filing the patent application which is related to this same invention but with the different application number, right? So this is called as divisional application. This divisional application, that means you divide your parent application into two. Patent of addition also has a parent application, but here you clearly know that I have done some improvement or modification in the parent application and I file a patent application for it. But in case of divisional application, I do not know at the point that there are two inventions in my application, and hence I can at any particular point of time, either myself or when the controller or the examiner tells me to do it, I can separate the parent application into two applications at any point of time before the grant of a patent. This is very important to understand. This has to be done before the grant of a patent. If you do not do this, patent office will either ask you to delete one of the inventions, or they can even cancel the patent for it if required, if at all possible, right? So this is what is very important to understand. So four types of patent application that we saw. One is the provisional patent application, other is the complete patent application, then there is a patent of addition, then there is divisional application, and the last and most important is referred to as a PCT application. PCT is also referred to as international application. This is also known as international application, and the full form of PCT is Patent Cooperation Treaty. Now this type of application is an application which is actually, which we are going to see into details in the next slides, I believe. But these type of applications are used when you are planning to file your application outside India in any of the countries. Let me reiterate here one important point. Patent is a territorial right. So though the PCT is referred to as international application, that does not mean that only one application needs to be filed and which will be applicable across the globe. No, it's a myth. There is no single document which will protect the interest of your patents in any of the other countries apart from what has already been uh, discussed or what has already been filed, right? PCT is only a kind of platform which we are going to see to details, but one application is to be filed at the PCT, and this application is referred to as a PCT application. In an exemplary scenario, the application which is filed in India as a complete application can be as it is filed in the PCT authority, WIPO authority, World Intellectual Property Organization Authority, which is a regulatory compliances monitoring for PCT. And if you file that application in PCT or WIPO, you will be given the PCT international application number and the date on which you have filed the application. We are going to see this in detail, PCT, in the next couple of slides. But at the moment, just for clarity, there are 5 different types of applications, patent applications. One is referred to as provisional, other is complete, third is patent of addition, fourth is divisional, and fifth is PCT. Moving on. So now, since we are going into details of the fees and the forms required, we need to again see the life cycle of a patent application, which we are seeing in, I think, from couple of sessions now. My intention of showing this cycle again and again is that after this workshop is over, till the date you remember this workshop happened, I don't want you to forget the life cycle of the patent application, and hence I am repeating it again and again, which will also help you to understand the forms and the fees required for it. So let us start with the first step. The color may change because in the earlier slides when I showed you the patent application life cycle, there was a different flow chart. Now this is a different flow chart which I have brought it in a elaborative manner. Sorry. So the most important step of life cycle of patent application is that you should file a patent application. If you do not file a patent application, how will the patent authority come to know that you have filed a patent application? On what basis they will grant your patent? So most important part is you need to file a patent application. That's the first step mentioned as 101. Second is step number 2, 102. If you recall, yesterday we discussed that the government of India automatically publishes your application, which is mentioned in 104, and the time period for that is 18 months from the date of filing of the application. Let us assume provisional application or complete application, whichever application you have filed first. From that date till 18 months, the government of India waits, and after that they publish your application automatically free of cost. But there are many people who do not want to wait for 18 months. So government also gives them option as mentioned in step number 2, that you file a request for early publication, and what we will do is like we will publish your patent application in 1 month's time from the date of filing of such request, right? So this is an optional step. So either you publish your application in 1 month's time, or you publish your application, let it publish your application in 18 months time from the date of filing of the application, right? This is an optional step. Moving on, there is a need for filing a request for examination at step 105. You all need to appreciate that it's a government office, it's a government body. So unless and until you pay some fees for doing the activity, they will not take initiative to do it automatically. So as per the requirements of the patent office, a request has to be filed at the patent office to publish to examine your application only happens which happens only after the publication of the application. So most importantly, let me rephrase and reiterate. The request for examination has to be filed by the applicant or the inventor, and the due date, or let us say the timeline for filing such request is 48 months from the date of filing of the patent application in India. This application may be a provisional application or it may be a complete application. Whichever application you have filed first, you have to file the request for examination within 48 months. That is the 4 years time period from the date of filing. If you fail to file this request for examination within 48 months, your application would be considered as abandoned, and there is no chance of revoking, or let us say re-invoking such application, and there will be no examination. Patent will never be granted for it. But yes, it will be in a public domain, and people may read your invention on the IPO site, Indian Patent Office site, but your patent will never be granted if you forget to file the request for examination. 48 months, that means 4 years time period is given by the government of India. What happens is like after you file the request for examination, patent office checks whether your application is published or not. If it is published, only when it is published, the patent office considers your application for examination. Okay, so this application for examination is considered means your application is actually reviewed by the examiner. So if you recall yesterday's session, there are examiners of the patent and they report directly to the hierarchy of the controllers. So either it may be an assistant controller, it may be a joint controller, it may be a deputy controller, or anybody, but examiners are the people who review your application. Now who are these examiners? Basically examiners are those people who are having either the technical background from the respective domain in which the application belongs to, patent application belongs to, or he is a person skilled in art in that particular industry, right? So for example, if the invention is filed in a pharmaceutical domain, a person or the technical person having knowledge or degree in pharma is considered as a examiner for that, which are actually employed by the government of India, and they examine your application. Now what happens during the examination? The same thing happens. What they do is like they do these things, they check these things. This is the job of the examiner. But where it happens only when you actually file a request for examination and after the patent application is published, right? What is the outcome of the examination? So for example, if you see in the step 107, so if the examiner feels that the patent application which you have filed, it has certain issues, it has certain problems. For example, if he feels that your invention is not patent eligible because of either of section 3, what we discussed in the slide couple of minutes back, he will say that I cannot grant you patent because this is invention falling under some criteria. Let me reiterate, this is just an examination report or opinion of the examiner. This is not a final decision, or this is not a final rejection. So this, at step 107, when the examination starts, the examiner issues an examination report with the various queries that he may have in his invention. So if the examination report is issued, obviously when the applicant receives such examination report, he is given a 6 months of time for replying to that particular invention, that particular examination report. So reply is nothing but our explanation or justification to the queries that the examiner may have and mention in the examination report, right? Such queries need to be responded. If you do not respond to this particular examination report within 6 months time period, your application is considered as abandoned and no further action can be taken for this. That means you will never get a patent granted for it. It will be cancelled. It will not be rejected, but it will be abandoned. That means due to failure of these things, there is no further status update for this patent application. I hope this is clear. Now, once the response is submitted at the patent office, the examiner again reviews your response in view of the application which is filed at the 101 step. Right? Is this clear? In his further review, if he realizes that yes, his objections or his concerns are cleared and he feels that the invention has a capability of getting a patent granted, at step 110, he grant the patent for it. Sorry, 109, not 110, 109. He grants the patent for it. Okay. However, sometimes what happens is like even after submitting the response and even after the examiner reading the response, he is not satisfied with some of the queries. So what he can do is like he has an authority to call us for the hearing. This hearing is nothing but a face-to-face discussion with the examiner or the controller, to mainly with the reason that to satisfy his queries as well as to uh, explain him or make clearer to him what the invention is and how it is different from the existing ones. So this hearing nowadays happens through a video conferencing call, but before couple of months back, it used to happen through physical, meetings at the required patent office. So for example, if the patent application is filed in Delhi, the Delhi patent office used to conduct these hearings at the patent office. Okay, this thing is clear. Perfect. Moving on, there is also an arrow which directly goes from after step 106 to directly patent grant 109. This is because in a very rarest situation, if the examiner has no queries at all in the invention and the invention is really satisfying all the criteria of a patent, then they will directly grant a patent. So it is not mandatory that the examination report would be issued. But as per my experience in last couple of years, patent office always issues at least one examination report for the examination. There are no inventions which are directly granted. This is my personal, in my humble opinion. I hope this is pretty much clear to you, right? So this life cycle is very clearer and it will help you to understand the perfect flow of the invention. So let me reiterate quickly what we discussed. Let me quickly revise, because this is very important and all other slides that we are going to discuss in next couple of minutes would be based on this particular flowchart only. So for example, the first application that is filed as a provisional application at step 101, what will happen is like we will be given 12 months of time. So before that, patent office actually allocates a patent application number for it and a date on which you have filed this patent application. So it is called as priority date or the date of filing date, either of these things. I'm not going into specifics of each of these dates because it will unnecessarily confuse you, but let us assume the date is the date on which first time you have filed the patent application in India. So here you have filed a provisional application. Government gives you 12 months of time to file a complete application. So 12 months of time are consumed in the complete application filing. So from the date of filing of the provisional application, after 18 months, this patent application automatically gets published after 18 months. That means you have already filed a complete application in those 12 months, and after 6 months from those 12 months, your application, which is a complete application, would be published. Now the question which should come in somebody's mind is that if we file a provisional application and if we file a request for early publication, then it should be published in 1 month's time, because that is what is the purpose of early publication. Then the answer to that question is that no, it never happens, because the only mandate to the provisional application is that all the further processing of the application happens only after you file a complete application. So you can use all 12 months to file the complete application, or you can even file a complete application within couple of weeks after filing the provisional application. Even in the next day you can file a complete application. It is not mandatory to wait for all the 12 months. But if you do not file a complete application, your application will never be published or it will never be examined. This is most important point to understand. So once a patent application is filed, if it is a provisional application, you have to file a complete application within 12 months of time. Or if you directly file a complete application, then automatically the next processing starts. So in case where you have filed a complete application directly at step 101, the publication request can be filed immediately for the publication in next 1 month's time. I hope this is clear and not very confusing. Now moving on, what happens is, like as I told you, for publication there are two let us say options available. One option is that the government of India automatically publishes your application on the government site after 18 months of time from the date of filing of the first application or the earliest application, be it provisional or be it complete. Okay, but this publication happens only after the filing of complete application. So 18 months time period is required for that. And second most important option is that if you do not want to wait for 18 months time, you can even publish your application by making a request to the officials or the examination authorities, and your application would be published in 1 month's time. So only criteria required for this publication is that your application should be filed as a complete application and not as a provisional application, because provisional application is neither published nor examined. This is the most important part to understand. After publication, what is a mandatory step that happens at the patent office is that you need to file a request for examination. If the request for examination is not filed, your application will not be taken for examination, and the patent office will never consider your application for anything voluntarily, right? So request for examination is to be filed very mandatorily, and the timeline for filing the request for examination is 48 months from the date of filing of the either provisional or the complete, whichever is earliest. 48 months, that means 4 years time. So what happens after filing the examination request? If the examiner at the patent office realizes that there are no queries in that, he will directly grant you a patent. But if he feels that there are queries, he has some doubts, then he may issue an examination report, and we need to prepare a reply or we need to respond to that. So the timeline for issuance of the report and in which he should either grant or reject the patent is 6 months time. So for example, if the examination report is issued today, then we have timeline of 6 months to prepare a reply or respond to the report. But normally the patent office expects that all the processing, including the hearing and or the grant or rejection of the patent, should happen within 6 months, which generally or normally does not happen. And thus the time period actually from the date of filing of the patent application till the disposal, that is either the grant or the rejection of the case, is 4 years or 48 months according to the Patents Act. Okay, so this is what is the overall scenario. So I was discussing that if we respond to the examination report and if the report is satisfactory, he will grant you a patent, but if not, he will call us for the hearing. This hearing is a face-to-face discussion which generally happens through video conferencing, and then based on that he will decide whether a patent is to be granted or not. I hope this slide is clear. We have discussed this twice, and let us move on to the next slide now, which talks about the fees required for this thing. There are a couple of important steps that we discussed here. The first most important step we discussed, the filing of a patent application. So once a patent application is filed, government office does not accept it free of cost. Though it is a government office and though it is a kind of serving office, uh, they expect a nominal fees to be paid for filing of a patent application. The nominal fees is INR 1600 rupees for the filing of a patent application if the application is filed as an individual. Now, what is the meaning of individual here is like it is a individual person or group of people, right? A person or a group of people are referred to as individual according to the Patents Act. Whereas any other entity, for example, if it is a college, if it is a company, if it is a organization, they are all referred to as a company. So INR 8,000 is the government fees for filing the patent application under the name of college or company. If you file it in your name as an individual, or there is no restriction on the number of individuals, but if you file it in the name of individuals, then the government fees is only 1600 rupees. So where is this applicable? Yes, in step number 101 at the time of filing the patent application. Second most important fee required is the fee for filing early publication. Where does early publication happen? Early publication as indicated in step number 102, if it is optional. So if you want to publish your complete application which is filed at step 101, and if you want to publish it, you need to pay the fees of 2500 rupees if the application is filed in the name of individual, that is your individual name or the group of people. But if you have filed the patent application in the name of college or company or institution or organization, then the official government fees changes to 12,500 rupees. This is the government fees, right? Now, what is the important step next? After the publication, what happens? Examination, absolutely. So a request for examination has to be filed compulsorily. If you do not file a request for examination, your application would be not considered for any further processing. This request for examination can be of two types. This is very important, people. We need to understand this, and it will be beneficial for you if anybody is interested to file a patent application. So first type of examination or example of the examination is referred to as a normal examination. So according to the normal examination request, you have to pay only 4,000 rupees fees as an individual, or if you are a company or organization or college, you need to pay 20,000 rupees. Second type of examination is called as expedited examination, as highlighted here. So here, if you are an individual and especially if you have a women applicant in the patent application, women applicant is very important here. If you are a women applicant, you can opt for expedited examination of your patent application. The fees is INR 8,000 rupees. Or if you are a college or an institution which is government affiliated college or institution, you can opt for this expedited examination, and the fees for that is 60,000 rupees. An obvious question that may come in one's mind is like, the fees is also on a higher side, and it is very expensive, then why should I opt for expedited examination? So there is a very simple answer to that. Let me come back to this particular life cycle. I told you very clearly that according to the Indian Patent Office, there are 48 months of time required for a patent to be considered as or to be disposed of, for patent granted or patent rejected from the date of filing of the application, which is the earliest one, right? 48 months, that means 4 years. This is the normal process. So according to the normal fees, if you pay 4,000 rupees or if you pay 20,000 rupees, you have to wait for at least 4 years for the examination and the deciding the fate of the case. However, if you opt for expedited examination, that means at the step 105, if you pay INR 8,000 rupees, provided that if you have a women applicant in the patent application, then this time period of 48 months which I just told you for the completion of this thing gets reduced to maximum up to 1.5 years. Maximum up to 1.5 years. We have seen patents getting granted under this expedited examination in 91 days time. That means not, I think, hardly 3 months time period. We have seen the patents getting granted. This is the difference, and thus the fees are high, right? So these are only the important fees that are required for getting a patent granted in India, right? This life cycle is for the patent application in India. Every country outside India also has a similar life cycle, plus the terms may be here and there, but we are going to go into details of that as well in a couple of minutes. I hope this point is clear to you. Only these three fees are important. So point number 3 and point number 4 are optional. So either you choose for normal examination or either you can pay for expedited examination. I told you the difference. If you go for normal examination, you have to wait for I think 3 or 4 years of time. If you go for expedited examination, you can expect the examination and the disposal of the case maximum in next 1.5 years. This is very important to understand. Is this clear? Perfect. So now with regards to the fees, how much would be the fees according to you for getting a patent granted? So if you yourself as an individual draft the patent and file the patent application in any of the patent offices, the only fees required, obviously not, let us consider that scenario as well. If you consider filing it with early publication and normal examination, the total fees would be somewhere around 8,100 rupees, if I'm not wrong, as an individual, right? So 4,000 plus 2,500 plus 1,600. Am I right? Perfect. So this is the fees for these things. However, if you choose for filing the application under expedited examination and early publication, then the fees goes to 12,100 rupees. These are only the government fees required for filing a patent application till the grant of a patent. The rights of a patent, we have seen so many rights of the patent till date, and it is the most concrete enforceable right in the in India, or in the world rather, patents. So this is what is the overall fees. If any one of you are interested to see various other fees that are involved in the patent process, you can refer to the site which is mentioned on the below. It's basically a fees document which will show you the different fees and different fee structures for any abnormal steps involved in this. So for example, if you want to add the name of the inventor at any point of time, if you want to delete the name of the inventor from the patent, if you want to license this particular patent to anybody, so you need to update it to the patent office. So all these are like not normal flow, or the not the steps of the normal flow of the life cycle, and thus I have not included it in that. This is the normal flow of the patent office or the life cycle of a patent. For any particular fees, you can note down this side. You can you can just click on this and you can see those required fees as well. Just for clarity, I'm also sharing these presentations with you so that it will be easier for you for future purposes also, like what we discussed on this particular part, right? So one most important advantage I would like to tell you, when I discussed with the normal examination and expedition part, expedited examination came into picture in 2016 when Make in India concept was brought into existence by Mr. Modi. Before that, there was no feasibility or possibility of expediting your examination of the case. So it is a very fortunate thing that this has recently been started. You won't believe, we are seeing the applications which are filed in 2009 and 10 still not even considered for examination, rather at the stage of examination, step number 106. Just imagine applications which are filed in 2010. That means 10 years has already been passed and these applications are not even considered for examination.